MSW Media.
So yeah, now it's clean up on aisle 45 time. And for a long while yet, it is going to be clean up on aisle 45.
Hey, everybody. Welcome to episode 254 of Clean Up on Aisle 45. It's Wednesday, December 3rd, 2025. I'm Allison Gill.
What's up, AG? Harry Dunn here. All right, we got a lot to discuss today. We'll jump right in it, including the ridiculous reason Pete Skandalakis dismissed the Fulton County 2020 election interference case. You know, AG and I were talking a lot about this, but wait till you hear this crap. And the Third Circuit Court of Appeals has upheld the disqualification of one Alina Habba as the U.S. Attorney for New Jersey.
Oh, womp womp, disqualified.
Womp, womp.
Yeah, these Skandalakis reasons are Skandalakis. They're scandalous.
Skandalakis.
It's just so dumb. It's just so dumb. And we're gonna talk about all that. Plus, we have an update in the case against, Milwaukee Judge Hannah Dugan.
Yeah.
She's the one who let somebody out of one door instead of another door, and so she's in trouble. And we have a new lawsuit filed by a former immigration judge who says she was unlawfully terminated because she's a woman and a Democrat. So we're going to talk about that interesting lawsuit. But first, before we get to the news, we have some new patrons to thank, including Jean Dorrell and April Adams. April Adams, if you are the April Adams that used to work at the Department of Veterans Affairs, send me a note. Otherwise, welcome the other April Adams. And we have some Hall of Fame patrons to shout out, as always. Jens Eilstrip Rasmussen, We Will Survive, Jeffrey Kincher, Lynn Bentley, Fran Reichenbach, Chris McCullough, January 20 Baby, Tiffany Trump Was Adopted, and Trisecular Manslaughter. So, thank you. If you sign up to be a patron at patreon.com/aisle45pod, you can pick whatever name you want. We'll read it on the air. So we appreciate your support. We couldn't do this without you, obviously. And, there's a lot that goes into this show. But I have to say that because of our patrons, because of the people who listen to this show, whether, you're a paid subscriber or not, and everybody else who watches all of our other podcasts at MSW Media, I actually made an announcement.
Yes, you did. Yes, you did.
I did this in response to Donald Trump's super racist Thanksgiving message, where he wants to remigrate. He wants to ethnically cleanse the United States, basically. And so Giving Tuesday, which was yesterday, I decided that I'm going to donate my entire annual Veterans Disability Benefit check to those that this administration intends to harm, including immigrants and the LGBTQ plus community. So, legal note, though, Harry, I'm not actually transferring that money directly. I am donating the equivalent.
Correct. Yes.
My personal funds. That's just a little legal disclaimer there.
Yeah.
But I was so angry when I read that message. I was like, how do I boycott this government? I have to pay my taxes, right? Or I'll go to jail.
Yeah.
But I don't want their slutty money. I don't want their fashy money. And so I'm going to send it all to people that they try to hurt. They need it more than I do. So this weekend.
That's big, AG. That's really great. That's really great. Shout out to Allison Gill for her big heart on Giving Tuesday. Yes, Giving Tuesday. Yeah. Doing the work. Shout out to you, AG. That's magnificent. Wow, words fail me, but that's fantastic.
Yeah, so thank you. I normally donate quietly, but I really want Donald Trump and Stephen Miller to know this year that all the federal benefits they send to me, I'm sending to non-citizens in the LGBTQ plus community in equivalent. But I will be traveling this Friday to the BRIC Awards for SIGB in New York to make a big donation there. It's an LGBTQ plus nonprofit group that helps create safe spaces for the LGBTQ plus community members. And so I'm looking forward to that. Do you have any travel coming up, my friend?
That's awesome. No, I don't. And I'm kind of happy about it. Well, I have a local thing. I'm speaking at one of the Democratic clubs in Maryland, their winter gala, 13th or 11th or 12th, somewhere of December. I have to look at the calendar, but that's coming up. But It's all local for me. But 2026, I definitely want to hit the road and hit it hard. I don't have to tell everybody here listening what's at stake. We all know. But we got to take the House back. Period.
We do. And we had when you listen to this episode, we will probably know who
the special
won
election in Tennessee.
7th district.
The fact
right?
that that's in play is just showing how pissed off people are with this administration. This was a district that Donald Trump and the incumbent won double digits. I don't have the exact number.
22 points.
22 points, Donald Trump. But it is in play. And the margin, it's within the most recent polling, we're within the margin of error, which is around 3 points or so. But the fact that this is this close, people are pissed off, people are angry. And now is not the time to sit on the sidelines. Now is the time for more and more people to get involved, to get engaged, and get into good trouble.
Yeah, we live in a time where a 22-point deficit is a toss-up. That's so, like, if you're going to run for something, if you've got anywhere near you a red district within 30 points.
Yeah. you're in play.
Whether it's city council, water board, school board, state assembly, to run for it.
Yeah.
If there was ever a year to win,
this is it.
It's this year. It's 2025, 2026. So we will see. Like, it's so weird because we record this show on Monday, that the election is tomorrow for us. But as you listen to this, it was yesterday. So we're hoping for a good result.
Yeah.
In that particular special election. Afton Ben, I mean, she's, like you said, within the margin of error. That just blows my mind. That is nuclear how close she is.
No, but like I said, that goes back to the bigger picture that people are pissed off at Donald Trump, and that in turns their piss off activity trickles down to Republicans and people who support it and enabled and normalize everything that Donald Trump's doing. Y'all had a chance to push back against this individual, that individual being Donald, and a lot of people didn't. And you know what? Voters are going to make you all remember that. And I'm glad.
Mm-hmm. Yeah, and people on both sides of the aisle are also really pissed off at Pete Hegseth right now.
Oh, yes.
He's in quite a bit of trouble. Well, I mean, not from Pam Bondi, obviously. She's not going to do anything. And I doubt the Uniform Code of Military Justice is going to go very far with him in charge. But he did give an unlawful order. And, you know, this new Washington Post reporting, pretty bombshell, that the admiral in charge of SEAL Team 6 saw after the smoke cleared after the very first boat strike, 2 individuals clinging to burning pieces of wreckage, and then went in again and blew them out of the water. That is, not only is it a war crime, Harry, it's actually the example in the Department of Defense Law of War Manual of what an illegal order is. That is the example that they use.
I wonder why Mark Kelly had to remind people. Jesus Christ, that's what this is about. That is an illegal order, and people followed it.
Yeah.
So actually, honestly, I believe people that carried it out and that followed that order are just as responsible. Isn't that how the UCMJ? Isn't that if you follow the order, you're just as guilty as the person giving the order?
Yeah, it says in the manual. For example, certain law of war obligations only apply to commanders or specialized units, such as units providing medical care, conducting detention operations, engaging in protection of cultural property. Case in point, although the specific responsibilities the individual combatants have to implement the principle of proportionality will depend on their role and assigned military duties. And it says in 18.3.2.1, clearly illegal orders to commit law of war violations. The requirement to refuse to comply with orders to commit law of war violations applies to orders to perform conduct that is clearly illegal, or orders that a subordinate knows in fact are illegal. For example, orders to fire upon the shipwrecked crew would be clearly illegal. Like, it's that is the example that's in the law of war manual. So
that's insane.
We know both parties in the House and the Senate want to now question this admiral that carried out the order to kill these two survivors.
And there's bipartisan calls for that, so which makes it likely that it will happen.
Yeah, at least this admiral will be dragged in. So we'll keep an eye on that. But man, there are a lot of people defecting from MAGA right now. That Indiana senator, Bohasic, who has a daughter with Down syndrome after Donald Trump called Governor Tim Walz the R word, said, well, I'm going to vote no on redistricting in Indiana, and this president can take 10 months in the corner and think about whether he deserves a congressional majority or not.
I'm glad that that's happening. But what about when he mocked the reporter? What about all that? What about grabbing women by the,
Well, that was before this particular Republican senator had a child with Down syndrome. It's only when it affects them and impacts them personally.
Yeah, and I think that's the point. It's only when it bothers them, it affects you. And that's why I'll die on this hill. Democrats care about people. Republicans care about themselves. And that, I think that is how do you define the two parties? That's the two parties in a nutshell for me.
Yeah, I remember when I interviewed Mary Trump when her first book came out, and her father sat down to lunch and her father was Donald Trump's brother.
Yeah.
And he had a drinking problem, and he sat down with Donald Trump's dad, their dad, for help. And Donald Trump Sr., or whatever, Fred Trump, I guess is his name. Freddie was like, Mary Trump's dad was like, help me, I need help. And his response is, what do you want from me? And so that kind of, to me, is the difference, right? Like, how can I help versus what do you want from me? Yeah. It's all transactional in that family. And that has, the fish rots from the head down. That's traveled throughout the Republican Party, that it doesn't matter to them unless it happens to them. And so it is now. And we're seeing a lot of cracks in the dam. So we're going to keep an eye on that. All right. As I said at the top of the show, we have tons to get to. Harry, you said it too. Yes. We have a lot to cover. So let's do that. But we're going to take a quick break first. So stick around. We'll be right back.
All right, everybody, welcome back. All right, as you probably know by now, this past week, Republican Pete Skandalakis dropped, to the chagrin of many people, the Fulton County RICO case against Donald and over a dozen other people after appointing himself the prosecutor. And now we promised we'd go over his reasons, which is it's crazy, which are totally divorced from reality.
Yes, I borrowed that line from Anna Bauer on Blue Sky. In a 23-page letter from the Prosecuting Attorneys Council of Georgia, who Skandalakis is in charge of, he wrote, in part, I begin the process of evaluating this case with basic truth. One basic truth. It is not illegal to question or challenge election results. Oh, my God.
So you see where we're going. Just from this is where we're starting, right?
Yeah, that's the jumping off point. He says, for the reasons in which I found Lieutenant Governor Burt Jones committed no crime in connection with the December 14th, 2020 meeting of the Republican electors at the Capitol, it should come as no surprise that I reached the same conclusion here. And that is correct. I was not surprised, but that was wrong, just as this is wrong.
Correct.
Specifically, he says the Republican electors lacked criminal intent in taking the actions alleged as overt acts in the indictment. And that is, bullshit. That is for a jury to decide. And only 3 of the 16 electors were indicted, Harry. So it wasn't like they were all indicted.
Correct.
They were indicted based on the evidence of intent, which was spelled out in the indictment. He goes on to say none of the electors were attorneys, and they cast their votes based on advice of attorney Ray Stallings Smith III. So if I call up Ray Stallings Smith III and ask him if it's cool to murder someone, and he tells me yes, Pete Skandalakis will say, hey, she's not a lawyer. And Ray told her it was okay. So that's an advice of counsel defense, which doesn't matter in a RICO case. and again, should be up to the jury to decide once the defense files a motion in limine to see if they can use, or a motion to, not a motion in limine, but a motion to use the defense of counsel or advice of counsel defense. This is just beyond ridiculous.
Yeah, exactly. The RICO count places significant emphasis on the breach of Coffee County election systems computers. The primary architect of the scheme, Sidney Powell, and a principal accomplice, Scott Hall, negotiated plea agreements with the state, reducing their charges to misdemeanors. Powell pled guilty to 6 misdemeanor counts of conspiracy to commit intentional interference with election duties, and Hall pled guilty to 5 misdemeanor conspiracy counts. Both of them received probation, provided statements to prosecutors, and agreed to testify in future proceedings. The evidence in the case file shows that Powell, an attorney, advised others that accessing the Coffee County computers was legal because it was undertaken for the purpose of gathering evidence in a pending lawsuit. The indictment further alleges, and evidence in the case file convinces me, Powell entered into contract with the company Sullivan Stricker, LLC, to access the Coffee County computers and paid the company $26,000 for the work.
Oh, all right. He goes on to say, in sum, Sidney Powell, an attorney regarded as an authority on election contest litigation, and who advised non-attorneys on the legality of accessing the computers, and Hall, who coordinated the computer intrusion, arrived by chartered plane and supervised the work, conveyed the appearance of acting under the color of law. The 2 principal actors, Powell and Hall, pled guilty to misdemeanor offenses. I'm convinced no further prosecution is warranted. So what he's saying here is all of the criminals in that, because Powell and Hall were the, I guess, attorneys in charge, and they pled guilty and they've been quote unquote punished. Again, that's so if Sidney Powell tells me to go murder somebody, it's all cool.
This guy's an idiot.
Yeah, it's ridiculous. He also says that the RICO count and many of the predicate acts continues to unravel when one scrutinizes the allegations against federal officials Jeffrey Clark, and Mark Meadows. The charges brought against Clark are especially concerning. They plainly fall short of the far more rigorous standard of proof beyond a reasonable doubt required to sustain a criminal conviction. Skandalakis says that because Clark's fraudulent and illegal letter was marked pre-decisional and deliberative, attorney-client or legal work product, that it's not a crime. So again, if I have a document that's fraudulent and I just put on it, work product, deliberative, we're just thinking out loud here.
All you got to do is write it on it and it makes it okay.
Yep. So I got to get a stamp that says pre-decisional and deliberative attorney-client or legal work product and just stamp that on all my documents. And then I can just, I can forge my signature and steal a bunch of money from someone's bank account and be like, sorry, this was deliberative legal work product.
Exactly. And that's totally not a crime.
And my lawyer, Ray, said it was totally fine. And
Skandalakis said it was also good too. So y'all know Skandalakis? Yeah, he's the expert.
That's it. For now on, I'm going to call it the Skandalakis defense.
Skandalakis defense. All right. And check this out. As far as Mark Meadows goes, Skandalakis says the White House chief of staff's job duties are varied and fluid. Yeah, fluid. All right. We could have a debate if arranging phone calls, observing the signature verification audit, or messaging an investigator to expedite the vote audit process falls within Mark Meadows' duties.
No, we cannot have a debate about that because it's not true.
It's not in the damn duties.
Judge Pryor in the 11th Circuit, who's a really conservative judge, he's the chief judge of the 11th Circuit, and he's a friend of Clarence Thomas, said, no, that is not anywhere near your duties. And that's why he wouldn't let him move his case to federal court. This guy, I hate this guy.
He's so full of it. It is plausible that Meadows believed it was his role to assist the president of the United States in obtaining clear information about what was happening in Georgia regarding the voter recount. The blurred lines between campaign duties and official duties do not provide an easy, obvious answer.
Yes, they
BS,
do.
they absolutely do. And like, this is not my interpretation. This is his words. His actions both in Georgia and in other states remain the subject to interpretation. What?
No, they do not. They don't. And there's court precedent for Meadows specifically.
Specifically.
Oh, my God. All right. Regarding the phone call to Georgia Secretary of State Brad Raffensperger, Skandalakis said, at no point did Meadows or Trump explicitly solicit the Secretary of State to violate his oath of office. What?
We've all heard
yes,
it.
They did. They even said the number of votes that they wanted him to find.
We've all heard it.
Says, he says, while the call is concerning, reasonable minds could differ as to how to interpret the call. No, they can't.
Oh my God.
But here's the explanation. He says, one interpretation is that Trump, without explicitly stating it, is instructing the Secretary of State to fictitiously or fraudulently produce enough votes to secure victory in Georgia. He did explicitly state that.
Correct.
An alternative interpretation is that President Trump, genuinely believing fraud had occurred, is asking the Secretary of State to investigate and determine whether sufficient irregularities exist to change the election outcome.
That isn't what he thought happened.
No, and Brad Raffensperger told him there wasn't, and so did 800 other people. And as it was stated multiple times in Jack Smith's indictments and in this RICO case, you don't have to, it doesn't matter if you believe that fraud occurred. That is irrelevant. That's absolutely irrelevant.
This guy is definitely gunning for an appointment in Trump's world, but this...
Yeah, maybe he can be the U.S. Attorney of New Jersey.
What a blowhard. Then he says, a genuinely sympathetic figure in this matter is Miss Ruby Freeman, falsely accused by Rudy Giuliani and others of voter fraud. Ms. Freeman endured harassment and threats from individuals who embraced the narrative that the 2020 election had been stolen from Donald. Evidence in the case files showed that the allegations in the indictment occurred solely in Cobb County, where Ms. Freeman resided at the time. If the RICO count was viable in Fulton County, this would not be a problem because venue in a RICO case lies in any county where an incident of racketeering occurred. However, the three people accused of the activity involving Ms. Freeman were so far removed and unrelated to the goal of the organization to unlawfully change the results of and to stop the vice president's certification of the 2020 election results. I find that these charges are too tenuous to be part of the RICO count.
So he had to come up with a reason why Ruby Freeman and Shay Moss, who are in Cobb County, could be part of this RICO case because that doesn't matter where the venue lies, right? And so what he's saying is, that's a different kind of crime than the enterprise to overturn the election results. No, it isn't, by the way. That they shouldn't be included. That's just... It's
crap. This guy is a scumbag, man.
He really is. He also says, as far as Trump goes, he says, and even if by some extraordinary circumstance, President Trump were to appear in Georgia on January 21st, 2029, the day after his term concludes, an immediate jury trial would be impossible. Litigating the immunity issues identified in Trump v. United States would require months, if not years, assuming the state could even prevail at the state level on those vigorously contested questions of presidential immunity. The presidential immunity is for federal cases, sir, not state cases.
Period.
In dismissing his federal case, Special Prosecutor Jack Smith acknowledged that unresolved legal questions remain concerning the scope of presidential immunity. Yeah.
On the federal level.
For the federal case. Some may argue that cases against the campaign attorneys and advisors should proceed. Oh, and by the way, Pete, Mr. Skandalakis, none of this is part of his duties as president. So they wouldn't be absolutely immune.
This was candidate Trump.
Yep. As Jack Smith said. Now, some may argue that cases against the campaign attorneys and advisors should proceed even if Trump is removed from the indictment. However, I'm extremely reluctant to criminalize the acts of attorneys providing flawed legal advice to the President of the United States under these circumstances. He's basically saying, I could take Trump off this and go after the other people, but I don't like to charge criminals with crimes.
Yeah, these criminals
they're
deserve
attorneys.
a pass.
Mm-hmm. Certainly, these lawyers should be accountable to their respective state bar associations for violations of professional conduct. Okay, so they did stuff wrong. And some have faced such accountability, but prosecuting these attorneys and advisors without Trump would be futile and unproductive. No reason given, just I don't feel like it. So
He's a
those
scumbag.
are
Man, what a terrible
divorced
dude.
from reality reasons. Pete Skandalakis took this case for himself and then dismissed it. And then, of course, Judge McAfee took his motion to dismiss and dropped the entire case. But what I want to know, Harry, is, he talks about a little bit that he went to a bunch of other DAs and nobody would take this case. But he didn't say who he went to.
I think he's lying.
Yeah, they didn't say who he went to or why. None of these other elected district attorneys in Cobb County, Coffee County, et cetera, wouldn't take this case.
Yeah.
He didn't say any of that. And that's what I want to know.
Yeah, I think he went in there with the mindset. I wouldn't be surprised if he had a call with Meadows and all the co-conspirators that were named, or not all of them, but a few, and said, it's going away, don't worry. I would bet money on it that call happened in some capacity. Don't worry, guys, it'll go away. I got it.
But calls don't count as crimes if
Correct.
you do it on the phone.
Hello.
He didn't explicitly ask him to violate his oath of office. Yes, he did.
Yeah, he did. That's literally what he did.
Oh, man. I can't.
I can't, sis.
Skandalakis. All right. We have other news to get to, everybody. We have to talk about parking lot lawyer Alina Habba and what the Third Circuit ruled this past Monday. So stick around. We'll be right back. All right, everybody, welcome back. Our next story comes from CBS News. A federal appeals court on Monday upheld a lower court decision that disqualified Alina Habba, who served as a personal lawyer to Donald Trump, and she was the acting, or I guess still is the interim acting U.S. attorney in New Jersey. A decision from the U.S. Court of Appeals for the Third Circuit was unanimous against the Trump administration, which has attempted to use a novel mechanism to place lawyers who have not received Senate approval into temporary U.S. attorney positions across the country.
Yeah, not so fast there, my friend. The case before the Third Circuit arose after 3 men facing criminal charges in New Jersey challenged the validity of Habba's appointment as a violation of the Federal Vacancies Reform Act and sought to have their indictments dismissed.
Yep. And a U.S. district judge named Matthew Brand ruled in August that Habba had been serving without lawful authority since the beginning of July, when she was installed to lead the U.S. Attorney's Office in New Jersey. Brand said she must be disqualified from participating in ongoing cases, although those charges against those defendants weren't dropped because other attorneys, assistant U.S. attorneys, signed on, unlike Lindsay Halligan, where she was the only one to sign it because no one was going to touch that shit with a 10-foot pole.
Hello.
These were actual cases. I don't know how legitimate they were, but they were at least more legitimate than the charges against Letitia James and Jim Comey. The Justice Department appealed that decision to the Third Circuit Court of Appeals, which is now the first federal appeals court to weigh in on the administration's scheme for installing certain U.S. attorneys.
I like they had to call it a scheme, because that's exactly everything about this is shady. It's a scheme, Habba was tapped to serve as an interim U.S. attorney in New Jersey earlier this year, but her appointment to the role was limited to 120 days unless the U.S. District Court in New Jersey voted to extend her tenure or she was confirmed to the post by the Senate. Habba's nomination, however, was unlikely to win approval in the upper chamber as New Jersey two senators, Democrats Cory Booker and Andy Kim, opposed her nomination.
Yeah, she was not going to get advice and consent to the Senate. Let's just say
Correct.
That. Now, ahead of the 120-day deadline, the judges in New Jersey declined to allow Habba to continue serving as U.S. attorney and instead voted to install her deputy, Desiree Lee Grace, into the position. After the 120 days are up, only the court can put a U.S. attorney in, right? Unless you can get somebody that goes through the Senate confirmation process. But that decision was met with swift pushback from Attorney General Pam Bondi, who fired Desiree Lee Grace. Then Trump and top administration officials employed a multi-step maneuver to keep Habba in the role and to get around the district court's decision. First, the president withdrew Habba's nomination for U.S. attorney in New Jersey. Then Habba resigned as interim U.S. attorney, and Bondi then appointed Habba as a special attorney and to fill Grace's role as the first assistant U.S. attorney. Finally, because the position as the New Jersey's top prosecutor was vacant, Habba was elevated to the role of acting U.S. attorney under the Federal Vacancies Reform Act. So it was this whole big dance, right? Withdraw her nomination, fire Grace, put Habba in the assistant U.S. attorney after appointing her special attorney at DOJ, and then elevating her to the U.S. attorney position. That is a workaround that is against the law.
This is too much going on. I feel like this is more complicated than like people that go couponing at like CVS or something where they just...
Yeah, if it's real hard to put her in that position, it's because it's illegal.
Somebody say, yeah, I bought $100 worth of stuff from CVS and I only paid 37 cents for it. Well, yeah, it sounds good, but all the stuff, it's a lot of work to go through it. And matter of fact, it's illegal here. That law, also known as the Vacancies Act, limits the government to government employees who can temporarily fill the roughly 1,300 federal offices that require nomination by the president and confirmation by the Senate. In their decisions, the judges on the Third Circuit Court found that the Trump administration's argument in support of Habba's role should raise a red flag, good for them, since it would allow the Justice Department to circumvent the Vacancies Act and effectively allow anyone to hold a U.S. attorney position indefinitely.
Yep. If it violates the law, it's against the law. Isn't that weird?
It's simple, weird and simple, right?
That's my legal interpretation of
Isn't that weird?
Now, Fisher was selected for the Third Circuit. These are the three judges. Judge Fisher, he was appointed to the Third Circuit by G.W. Bush, and he was joined in the decision unanimously by Judge L. Philippe Restrepo, appointed by Obama, and Judge D. Brooks Smith, tapped for the Third Circuit by Daddy Bush. So it's a very split panel, but they unanimously agreed. The Trump administration has sought to install temporary U.S. attorneys in Nevada and Los Angeles. That's Sigal Chattah, if memory serves, and a guy named Asali in Los Angeles, using this exact same mechanism that it deployed for Habba, but they have faced resistance from the courts there too. The most high profile of those decisions came last week when a federal judge ordered the criminal charges against former FBI Director Jim Comey and New York Attorney General Letitia James to be dismissed on the grounds that Lindsay Halligan, the interim U.S. attorney who secured their indictments, was unlawfully appointed to her role. So this, we could see the guy in New York next, by the way, because he was made the assistant U.S. attorney and then deputy and then appointed himself. The same thing happened in New York. So we're probably going to see something happen there too pretty soon.
It's funny when the dam starts to break, like all the people like, we did this illegally. So it's just all the dominoes are starting to fall down. So
yeah, they are.
Just follow the damn law. Appoint people, get them confirmed. It's simple, right?
Yeah, that's hard to do when you're appointing completely
unqualified
loyal,
assholes.
Unqualified assholes. Yep. Well put, my friend.
All right, next up from NPR. Tanya Namer is one of dozens of immigration judges fired by the Trump administration this year. But a new lawsuit filed in Washington, D.C. suggests what happened to Namer and why has the potential to scramble the federal workforce and upend foundational civil rights laws.
Yeah. Now, Namer alleges that despite top performance reviews, she was dismissed from her job because of her gender, her status as a dual citizen of Lebanon, and the fact that she once ran for municipal office in Ohio as a Democrat. Those reasons, she says, are all in violation of the Civil Rights Act of 1964 and the First Amendment. And I fully understand this position because I, too, was fired from the executive branch despite top performance reviews because of my gender. I'm not a dual citizen. I did run for a Democratic office at one point, and also because I had a big old podcast about the Mueller investigation. Now, the government, by the way, my litigation is pending, just so you know.
Just saying.
Yeah, the government has responded by arguing that the president's power to oversee the executive branch under Article 2 of the Constitution overrides that civil rights law. That's what Namer's attorney says. That's what his thing is for everything. He always says, under my powers under Article 2 of the Constitution, you're fired.
The president can do whatever he wants. Article 2.
Yeah, Article 2, Article 2. Quote, this is a case in which the President of the United States has asserted a constitutional right to discriminate against a federal employee. That's what her lawyer said. Her lawyer is Nathaniel Zelensky of the Washington Litigation Group. Went on to say, if the government prevails in transforming the law, it will eviscerate the professional, nonpartisan civil service as we know it.
Well, the administration abruptly fired Namer in early February, summoning her from the bench and escorting her out of a federal building in Cleveland. Both her supervisor and the chief immigration judge there told they didn't know why she was being dismissed in the middle of her probationary period, the lawsuit said. Federal workers on probationary status have fewer rights to contest their firings than other civil servants do, but they are still covered by constitutional protections, barring retaliation from their political speech, and civil rights laws that prohibit discriminations on the basis of race, sex, and national origin.
Yes, indeed. Namer filed a formal discrimination complaint with the EEO, Equal Employment Opportunity Office, a month after she was fired. That office dismissed her claim in September, asserting that in its decision that Title VII of the Civil Rights Act conflicts with the president's power to remove federal workers within the executive branch. The implications sweep far beyond a single immigration judge. Quote, according to the final agency decision, the president may now fire female federal workers like Miss Namer because of their sex, and the law would have nothing to say about it. That's according to the new lawsuit. According to the final agency decision, the president can now fire federal workers born to immigrant parents with dual citizenship like Miss Namer because of their national origin, and they would have no recourse. And under the same logic, the president can fire federal workers because of their political activities and affiliations, and the courts would be powerless to act. That's all a civil rights violation.
Article 2.
Mm-hmm.
Namer is seeking reinstatement, back pay, and an order erasing her termination. She said she never got official notice about any reasons for her dismissal.
Yeah, I am not, in my case, I'm not seeking reinstatement.
Yeah.
but I am seeking back pay. So
you should amend your complaint. I am seeking back pay and an apology.
That would be fun. You have to say sorry to my face.
You have to say sorry on the biggest platform you have. Yeah, I would so do that.
I need fresh flowers every month.
Absolutely.
From Bokes.com. All right, everybody. We have one more story this week. It's not Rudy news. And we don't have an update on the Hunter Biden, Patrick Byrne circus of a case, where he was asking for $33 million because Patrick Byrne, the Overstock.com CEO, defaulted. That's still pending a decision. But we do have the decisions for motions in limine in the Judge Hannah Dugan case. And this is a case in Milwaukee where the judge let one of the immigrants in her courtroom leave through the door from the jury room instead of the main door in the courtroom, which are like 3 feet apart, and they go to the same hallway. And so she's been brought up on charges of aiding and abetting that immigrant. By the way, that immigrant has been deported now, but she has filed, and the government has filed something called motions in limine. And Harry, those are basically, we'll explain it in a little more detail after the break, but it's basically what you don't want brought up into evidence or testimony during the trial and why. And Judge Dugan largely won these motions, won this round. So we're going to talk about that. We're going to keep score, but we have to take this last break. Stick around. We'll be right back. All right, everybody, welcome back. Like I said, no Rudy news, no Patrick Byrne news. We'll keep you posted on those. We do have that update on the case against Milwaukee Judge Hannah Dugan, who's been accused of aiding and abetting an immigrant by letting him use an exit just to the right of her courtroom doors that goes out into the same hallway. The parties filed their motions in limine. Again, those are those requests to prohibit the other side from doing stuff in court. So, for example, we want to prevent the government from bringing up my past personal relationships in court, stuff like that. Judge Dugan, like I said, won most of this ruling.
The government asked for 13 things, most of which Judge Dugan didn't object to. For instance, the government asked the court to prohibit Dugan from bringing up possible consequences or punishment as a defense. That's pretty standard, and Judge Dugan didn't object. The government asked to prohibit Dugan from eliciting extrajudicial statements, and Dugan objected. And since the government didn't specify which statements, that request was rejected.
Okay. So we got the first rejection of the government's motion. So it's 1-0 Dugan. Next up, the government moved to bar argument or questioning concerning the motives of law enforcement. Now, Dugan objected to that, saying their motives are really important here, and the judge agreed with her. So now it's 2-0 Dugan. And the indictment, this is from the court ruling. The indictment alleged that the defendant, Dugan, falsely told ICE agents they needed a judicial warrant. The government argues the defendant should be precluded. She shouldn't be able to argue that a judicial warrant, as opposed to administrative warrant, is needed to arrest an alien in a public hallway. Now, Dugan objected to this and won because it's true. So now we're 3-0 Dugan.
3-0 Dugan. Next, the government seeks to bar evidence or argument concerning defendant's arrest or alluding to alternative means of bringing her to court for initial appearance, arguing that the only purpose served by introducing such evidence would be to invite jurors to find fault with the government or conclude that the defendant already had been punished for her wrongful conduct, encouraging jury nullification. Dugan objects, arguing she must be permitted to discredit the caliber of the investigation or the decision to charge her. Defendant should be permitted to challenge the integrity of the investigation. However, it is unclear why this would include evidence about her arrest. Absent further explanation as to how this could be relevant, the government's request will be granted. Now is 3-1 Dugan.
Okay, so the government wins one, but basically because Dugan didn't explain why that evidence about her arrest would be relevant. She can do that and maybe win this one back, but she didn't here. So the government won that, and she cannot provide evidence or argument concerning her arrest or alluding to alternative means of bringing her to court for an appearance. Next up, the government moves to bar evidence or comment concerning the duration of the investigation, that it was really short. And Dugan objects, saying that the haste here is relevant because it goes to bias and sloppiness. And the judge said, yep, that'll be decided at trial, so I'm not going to bar that. And now it's 4-1 Dugan. Next, the government moves to bar argument that Dugan should not be convicted because she did not succeed in preventing this guy's arrest. And Dugan objected, saying to her proposed jury instructions, including an element of materiality. It's not material if it didn't work. And the judge says she's going to defer that until trial. And that kind of means like, we'll let you make these arguments and have objections as it goes along. But the government lost this one. So now it's 5-1 in favor of Dugan.
Yeah, then the government moves to bar evidence of other ICE enforcement actions in Milwaukee County Courthouse or elsewhere. The judge said, I agree with the defense that such evidence may be relevant to the defendant's mental state. This request is denied. 6-1 Dugan. 6-1. Next, the government moves to bar evidence of the defendant's alleged good motives, arguing such arguments have the potential to mislead the jury because they suggest the defendant was privileged to break the law because of her moral beliefs or good motives. The judge said, absent more specifics, I cannot definitively rule on this request. Defendant will be allowed to present relevant evidence touching on her mental state. 7-1 Dugan.
Okay. So she can say, I was trying to do a good thing. Interesting. And again, the judge here said, absent more explanation, I'm going to rule in favor of Dugan here against the government, but the government can provide additional information if they really want to fight this. Now, the last two things are that the government moved to bar evidence of the defendant's prior good acts, noting she may seek to introduce evidence of her past law-abiding conduct. Like, she's done all these great things. She's a judge. Now, the judge in this case says that's not specific enough. and we can deal with that as it happens at trial. So Dugan wins that one. It's 8-1. And that brings us to Dugan's requests. Okay. So we're 8-1. That's 9 things. The other 4 things that the government wanted, Dugan didn't object to. So those are the totality of the 13 things. So we're 8-1 Dugan, and now we're going to go on to Dugan's requests. She argues that because lawful acts do not and cannot obstruct or hinder under Seventh Circuit case law, the government may not rely on or even introduce evidence of these lawful acts. Alternatively, the government may not contest that they were official acts within Wisconsin within her job. This is part of her duty. The judge said in this case, I've already ruled on judicial immunity, so that motion is denied. So that means the government can rely on evidence of lawful acts. So now it's 8-2 in Dugan's favor.
8-2. Okay, next, Dugan moves to prohibit the government from arguing or eliciting testimony that she violated Chapter 950 of the Wisconsin Statutes or Article 1, Section 9 of the Wisconsin Constitution. This is the state victims' right provisions, arguing such evidence would not be relevant and would be substantially prejudicial. She further argues that allowing such evidence would create a mini trial on an irrelevant issue. The judge agrees and grants this one 9-2 Dugan.
9-2. All right. I'm not real familiar with Chapter 950, and it doesn't really go into it in the ruling here, but Dugan is allowed to prohibit the government from arguing testimony that she violated it. It would be considered a mini trial, and the judge is like, we're not going to do that. So
we're not doing that.
She rules in favor of Dugan. Next, Dugan seeks permission to elicit statements made to the media and on social media by the Attorney General and the Director of the FBI about her alleged actions on April 18th, 2025. She contends that such statements are admissible. This is Pam Bondi and Kash Patel, what they said on social media. She says that those statements are admissible because they're made by a party opponent, and they're relevant because they show bias in the investigation and prosecution. Now, the government says, while bias is broadly admissible on issues of credibility, neither Pam Bondi or Kash Patel are going to testify in the case. And so the judge says, without more information, she agrees with the government. The defendant should not be permitted to inject national political figures into the trial. Any slight probative value that the evidence might have is substantially outweighed by the danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, and wasting time. So this was one big loss for Dugan in this. She's not allowed to enter those statements by Pam Bondi and Kash Patel into evidence. So this motion in limine was denied. So now it's 9-3 Dugan.
I gotta feel like, AG, that even just with that specific request right here, they will open the door themselves and bring up those statements, or somehow Kash Patel or Pam Bondi, and then that opens the door for Dugan to get those statements in. These attorneys generals or AGs cannot help themselves when seeking praise from Pam Bondi. So all other requests, like I said, all other requests were not objected to. So it's 9-3 is the final tally in favor of Judge Dugan. And I know it's not really about keeping score. I like keeping score, though. But I wanted to illustrate that in the case, when you run a headline that says Judge Dugan loses or whatever, she kind of didn't.
That's not true.
That's not true. We'll keep covering this, and y'all can listen to updates here because we will bring them to you.
Yeah. And so everything else was pretty procedural, but that one, Judge Dugan won everything basically, except for, being allowed to bring in Pam Bondi and Kash Patel's statements. And I think the judge didn't say in that case that without more information, I have to deny this. She actually said that this would be more unfair and prejudiced than it would be probative. So because it outweighs that. So I don't think that Judge Dugan can, file anything supplemental to get her to change her mind on that. All right, everybody, that's our show. I know it got a little bit legally wonky there at the end, but I'm with you, Harry. I saw a bunch of posts like Judge Dugan loses this round or whatever, and she fully did not.
Wait, she did not.
Yeah, she lost one major thing and a couple of little things, and then won the rest of them, and the rest were uncontested. So I thought, yeah, it was. I'm glad that we went through that and kept this little tally going on who got what. I hope that she's acquitted, and I hope that there's some sort of jury nullification or that they find some reasonable doubt here, and she will be able to talk about her past awesomeness, but she can't bring up that she's a judge and immune. So it'll be an interesting trial, and we'll be covering it here. All right. Anything else? Any final thoughts going into the rest of this week? We're on the back end of this week now, and time seems to be going really quickly. We're almost a year into this administration. It's kind of amazing how quickly he got a bunch of Republicans to abandon him.
Yeah, he sure did. And also, we're coming up on, are we here yet? Yes, my 1 year with the show.
Yeah.
This is when I took over for our dear friend Pete, and I couldn't have been happier to be a year with you, my friend, and in the ears of everybody that's tolerating me right now. So I love you, and thank you for making this year seem to fly by already. So this is great.
Yeah, the faster the time goes under this administration, the better off we all are.
Absolutely.
Pete, by the way, says hello to everyone. He's doing well, as does, of course, Andy and Dana and everybody else at the MSW Media Network. Oh, and if you get a chance, if you have some time, I am obsessed with the Martin Sheen podcast.
Oh,
you have to listen to this. It's so awesome. I don't even know how to categorize it. You just have to check it out if you get a moment. It's only like 20, 25 minutes per episode. And there's like 4 episodes out now. It's amazing. I'm obsessed with it. So check that out. And also, if you get a chance, over on my Substack, MullerSheWrote.com, I have my latest Midas Touch show up there where I go email by email. Because Jason Leopold, the FOIA whisperer, he's really good at Freedom of Information Act requests. He got like 75 pages of internal FBI emails about the redaction project of the Epstein files. And it's pretty telling what he shows. And I put all those emails up and show it side by side of some of the reporting that it confirms. So anyway, everybody, I hope that you have a wonderful rest of your week. Of course, we'll see you later in the week, patrons, for the bonus episode. And we'll be back in your ears next Wednesday for the public episode, which I will be recording from New York City. So I appreciate all of you, and we'll see you next week. Thank you so much for listening to Clean Up on Aisle 45. I'm Allison Gill.
Harry Dunn. Thanks, y'all.
Clean Up on Aisle 45 is written, researched, and produced by Allison Gill, with editing by Molly Hockey. Our art and logo design are by Joelle Reeder and Moxie Design Studios, and our music is composed and performed by Adam Orr. Clean Up on Aisle 45 is a proud member of the MSW Media Network, a collection of creator-owned podcasts dedicated to news, politics, and justice. For more information, visit mswmedia.com. MSW Media.